Hello, aspirants. Welcome to PW OnlyIAS. I'm here, Harpreet Singh, with the daily analysis of the Hindu from 12th of December 2024. Let's begin with today's analysis. This is a QR code where you can basically find the particular PDF that we are discussing, along with other material that is required for your preparation. So, what all topics we have taken for today's analysis? These are quite interesting, quite debative topics also. First, a very interesting topic which is in the news. Are laws women biased? Second, issue of manual scavenging. Then, right to disconnect. And then, impeachment of a judge. Then we had an editorial also, so we have to understand what Vaikom Satyagraha is. Then we have the Voronezh radar, and then we have the India Skill Report 2025. Let's analyze what all these topics basically say. The main topics. Now, this was the article that was present in your The Hindu in today's newspaper. Now, what do we see over here? See, a techie death victim's family demands justice and seeks strict action against the harassers. Now, the topic that I've taken over here is, are laws women biased? Now, please understand something, why I have taken this article. Let us see the context over here. The context over here is, there was an artificial intelligence engineer, 34 years old, and the issue with respect to harassment by his former wife, and with respect to alimony, and with respect to the judge and the family of the wife, the issue that arose basically frustrated him to such an extent that he said that he's taking his life, or let us say committing suicide. And that is why the issue over here comes that are the laws biased? That means when I'm talking about biased, I'm talking about, are they favoring one particular gender? One particular gender. Why did this actually happen? So that is why it has sparked a debate that let us analyze whether these laws favor the women over here and are they against man. So let us analyze this particular topic. See, first let us admit that we will never deny that there is a rise in crime against the women. We see over here, we realize that according to the National Crime Record Bureau, registered cases of crime against the women have risen. There is no doubt about that, right? There have been nature of crimes like cruelty by husband and relatives 31.4%, kidnapping and abduction 19.2%, assault to outrage the modesty, rape. All these cases have been there, and we realize that if we see 2021 and so on and so forth, the cases have risen, and there is no doubt. So that means the trend that we see is that there is a rise in the cases against the women. We will not deny that. But do we see that over here, this report that has come, that is talking about women? Does it talk about the issues that the men also face? What type of trauma or mental harassment that men might be facing? Now, this is where comes the report by World Bank. Now, this World Bank basically released its report few years back, where it basically categorized the violence percentage with respect to men and women. Now, see, this over here, the orange bar basically represents, this whole is representing women or girls, right? The girls. This is basically representing the boys or percentage of men, right? Boys. If we see any form of violence that is faced by women, out of the total percentage of the girls that are basically surveyed, 77% said yes, they face one or the other form of violence. But 79% boys said that they also face some or the other form of violence. Similarly, out of the surveyed girls, 72% said that they have faced some or the other form of physical violence. And 75% boys or the men said they also have faced physical violence. Then what happened? Sexual violence. Out of the surveyed, 20% said that they have faced sexual violence. Among the boys, 12% also said that they also have faced one or the other form of sexual violence. Then comes emotional violence. It is very shocking that according to the report also, we see 28% of the women or the girls said they have faced emotional trauma. 32% men said that they have faced emotional trauma. Now, when you see these stats, do you realize that we generally, when we report about the issues that women are facing, that is true, we are not denying that. But do you realize, is this section neglected when we talk about their issues or what type of trauma they are facing? Because, see, let us take an example. When we are talking about issues of sexual violence, we agree that majority of the cases of sexual violence are happening against the women. We agree to that. But there are large number of cases in which sexual violence of the men also might be happening. But because India being a patriarchal society, those cases are not reported only. When the man, let us say a boy or a man, goes to the police station to report that that particular boy has been sexually harassed by a girl, it becomes a point of mockery. And that is why the boy even does not go and report that. So those are also the cases that one need to understand and remember that is being faced by the boys and the men of today's time. Now, having understood the two perspectives, first being that yes, there are crimes, we admit it. Then we realize the World Bank report where there is emotional trauma and violence against both men and women. Now comes a very important study. Please understand, this is for your knowledge also, because there are a lot of laws that have been discussed over here. Misuse of law by women in India, constitutionality of gender bias. Now, you don't have to remember this for general studies that who has reported, who has done this. This is just as a proof that from where I have taken this particular article. There are three writers over here who have basically analyzed the various laws in India. And they've said there is a gender biasness present in them. Let's see them. So let us have a look at the certain laws. If you see section 497 of the Indian Penal Code, which criminalizes adultery, please remember that adultery as a criminal offense, again, it has been decriminalized. But if you see the previous or the old acts also, you will be realizing that there was an element of the men being basically treated as a second-rate citizens over here, and the biasness was towards the women. So let us have a look at them also, then we'll analyze it. Where criminalizes adultery but only punishes the men for having sexual relationships with another man's wife. Over here, the wife of another man will not be touched over here. But the man over here would be punished because he has committed adultery. So that means it did have a bias. Though now we realize that adultery has been decriminalized. Now, if you see, there is a very important case over here also. Recently, when we see adultery being decriminalized, over here, let us assume, let's take an example. If this is a man and he is married to a woman here, right? Let us say W1. Let this be a man, he's married to a woman. And let us say there is another man, there's another woman over here and another man over here, right? Now, supposingly, these two are couple. Now, this man basically commits adultery with this particular woman. In this particular case, remember what happens is that this woman can ask for divorce because his husband has committed adultery with this woman. So that means it is a ground for divorce because women can ask for it. But in this particular case, because a woman has committed adultery with this man cannot ask for divorce in the court. That means when a man is committing adultery, the woman can ask for a divorce, right? But over here, when the woman is committing adultery with a man, this man cannot ask for a divorce in the court. Now, this is again a judgment that because on the various judgments that have been given, that creates problem with respect to the biasness that is there. Next, the Muslim personal law in India also has been criticized for being gender biased because the Muslim law does not have the same rights as to man in cases of inheritance, divorce, and the child custody. The source is Muslim Personal Law Shariat Application Act 1937. Section 1554, subsection over here, basically places a burden of proof on the victim in the cases of the sexual assault. Then we realize over here also that the burden of proof will lie on the person who has committed an act rather than the proceedings going on, and over there one has to prove that he has not committed, rather than the side of the victim proving that the action has been committed. So by default, in case of a rape, the person who has been accused is already found guilty over there. So that is why the onus would lie on the person to prove that he has not committed the crime. So again, it is a biasness towards the male is also present over here. Again, we realize that adultery as a criminal offense only criminalizes the act of man. We know that it has been decriminalized, but we realized that earlier on also, that the biasness was towards the man, because it was a man who had against whom action could be taken, not against the women. So again, that is a problem. Now, if we move ahead, we realize over here, honor killing, which is often committed against women, is perceived to have violated the traditional gender norms in the form of gender crime. Please understand, even the Indian Penal Code 1860, Section 300, basically places the onus on the man that he has committed an act. And again, in that case also, the man is assumed to have committed a crime without any, let us say, proceedings going on, because once you are charged under this act, it is the person who is accused who has to prove that he has not committed the act. That is why it has a biasness against the man over here. Remember again, crimes related to dowry and dowry deaths, harassment for dowry is also a form of gender bias, where we can see Dowry Prohibition Act 1961, under which a non-bailable warrant can be released, and in that case also the groom or the groom's family has to prove that they have not asked for it once they are charged under it. So again, it has a biasness against the man. Acid attacks, which are often committed against women and girls, a form of revenge or punishment, another form of gender bias which is prevalent. Now please understand that in these particular crimes also, there have been instances when what happens is, a girl says that this particular man has committed a crime. It is quite possible that the girl might have preconceived notion of that particular person doing, but he might have not committed it. But because the girl has charged that this boy has done it, under those circumstances, the boy has to prove that he has not done it. That is why there is a biasness with respect to the laws that are against the men. Next, we move ahead. There are some examples of women protection laws also, but you realize this. There's a act, the Protection of Women Against Domestic Violence Act 2005. Under this particular case, if you realize, it provides protection to women from domestic violence and abuse, including physical, emotional, and economic abuse. Now, over here, please remember, any girl that files a domestic violence act, it is first of all, earlier on, it was merely interpreted from the aspect that the husband has committed the offense of domestic violence. So, the moment a domestic violence act is committed, the husband is charged with the offense. Now, the court has even expanded the definition that even the family of the groom or the husband may have also committed, that can also be included in the domestic violence act. So over here, the moment a girl files a case, then the police has to again arrest the husband. Please understand, over here, large number of fake domestic violence cases are filed against the husband, because possibly the girl is not happy with the husband. They want to get divorced, but under normal circumstances, the divorce is not being met or the husband is not agreeing. So there, various fake cases are filed, and this is something that even the Supreme Court has basically stated in one of its judgments, that there is tremendous rise in the fake domestic violence cases that are filed against the men. Now, Sexual Harassment of Women at Workplace Prevention, Protection and Redressal Act 2013 requires all employers to have internal complaints committee to address the complaints of sexual harassment and workplace. Do you realize this act is about sexual harassment of workplace to protect the women? Now, assumingly, if a man is in a position in a, let us say, firm, and possibly a girl's like that boy, and the boy says, no, I'm not interested. And supposingly that hurts the ego of a woman, and she files a case of, let us say, sexual harassment at workplace. In that particular case, you will be realizing that this act provides sexual protection against the harassment only to the women, not to the men, not to the transgender also if they're working in the office. So why? Why have men been excluded from this? There's a possibility that men can also be exploited, because in the corporate culture, if you realize, there are men who and women equally competing in the for the post. It is based on meritocracy. When meritocracy is there, you realize that there's a possibility that even women, or for that matter men also, can do such offenses in order to gain their position. So this, we realize, is again favoring the women, not the men, or nor are they gender neutral. Next, now there is a case study. Please see this. Section 498A. 498A. What does this say? Section 498A provides imprisonment for 3 years or a fine for a man and his relatives if they subject his wife to cruelty. Directly. Now, if a man or his family basically does something that comes under the definition of cruelty, you can be subjected to imprisonment for 3 years. What is cruelty? Cruelty is defined as willfully driving a woman to commit suicide or inflicting grave injury, including physical or mental, upon her. Now just assume if there is a fight between between a woman and her husband, and she thinks that because a comment has been passed and I have been subjected to about to commit suicide. Now under that case, even do you realize the subjectivity to which a woman can file a complaint against Section 498A? That means even a small small, let us say, argument can be presented in the form of a police station that I was about to commit suicide because my husband did this or spoke this. Under this, the man will be charged. The problem with this section again is, please understand, firstly, let us see, it was introduced in 1983 to prevent domestic violence and murders caused by the in-laws. But see what has happened. It is non-bailable. The moment the husband or his family is charged under this section, you'll be arrested and you will not get the bail. Second, non-compoundable. It means that cases cannot be settled by both the parties. Once the girl has filed a case, it is not that you both the parties sit together and resolve the issue and it is done. No, once it has been filed, it is the court has to intervene now. You cannot settle among yourselves. Cognizable. This means that police can make or arrest proceeds without any arrest warrant from the court. Right? Without any warrant from the court, the police can arrest. So do you realize this is one of the very dangerous section which is very often used by women to charge the men for even small minor problems that they arise. If they are not compatible, in that case also this can be invoked. Now what happens is misuse of law. Fake cases filed under section 498A of IPC accounts for over 30% of the total crime against women. So 30% of the crimes that are reported are registered under this particular section. And however, the conviction rate stands at 12.1%. The reason behind it is that many of them are fake also. Experts have pointed out that most of the cases are not related to dowry demand. It is because certain fight might have happened between the couple and the girl might have filed the case. Extortion or blackmail. Again, please understand, legal experts have opined that cases are being settled on payment for money. Remember, the girls over here, and various cases have come up where the girls might be saying that we will file a case under this particular section if you do not give us this amount of money, or let us settle it and get divorced and you pay this money, otherwise I'll charge you under this particular section. That is why even the Supreme Court has said that section 498 is a dubious place of pride amongst the provision that are used as a weapon rather than a shield. So that means by disgruntled wives. So the Honorable Supreme Court has said that the disgruntled wives or the wives have been using it as a weapon rather than using it as a protective measure. This is again a case study. You can see how the biasness is particularly present over here. Now, what should be done to eliminate all this? See, what we require is that there should be gender neutrality, not biasness of favoring one particular gender or a sex. Because see, the problems, we realize that problems are being faced by women, but they are also being faced by men. So if there is some problem, or let us say issue that is concern that is there with respect to any gender or a sex, it should be addressed by the court irrespective of having a biasness against, or let us say biasness in favor of any particular gender. That is why what we realize, we need gender neutral laws in a country. Like for example, the POXCO Act is a gender neutral act. Whether it is a girl child, whether it is a boy child, it does not discriminate between them. That is why it is a gender neutral. Similarly, other laws should also be made gender neutral. So what can be done? Establish a legal system that is gender neutral. For example, we have POXCO Act. So that is basically an example of the gender neutrality. Does not discriminate against women. This includes ensuring equal pay for equal work for all. Implement stricter laws and harsher punishment for those who misuse the act. Establish a system of reporting, tracking, and punishing those who abuse the law. Provide legal aid and support to victims of abuse and who misuse the law. Create a legal system that is responsive to the need of the women and aware of their rights. We need to raise awareness also. That awareness about if you misuse a law, it is the one against whom action can be taken. Educate the public on importance of respecting the law and proper use. Create awareness campaigns to focus on empowering and protecting women. Strengthen the judicial system to ensure justice is served. Provide more resources to the police and legal authorities to enable them and more effectively investigate and prevent any misuse that has taken place. And finally, encouraging citizens to report any misuse of law. That means reporting it also becomes very, very important. So these are the things. So what do we come to a conclusion over here? Acts like POXCO, which are gender neutral, right, which are preventing any harassment or any sexual exploitation against the children, it does not discriminate between men and women, or let us say boy child or the girl child. That is the type of laws that we need at the level of the people who are adult also, so that there is a balance and no discrimination against any citizen. Like we talk about right to equality under Article 14. Basically, when we see these many people coin them or see them as positive discrimination, but when that positive discrimination is being misused, then there is a necessary intervention that the government and the judiciary, as per required, should make, so that we all are at a level playing field. Let's move to the next topic. Topic 2, manual scavenging. Will go to any extent possible to eradicate manual scavenging, said Supreme Court. Now, please understand, this concept of manual scavenging is something that is very problematic in India with respect to the stigma that is attached to it. First, let us understand what do you mean by manual scavenging. See, manual scavenging is a practice of removing human excreta by hand from sewers or septic tank. Sewers or septic tank, using your hands or manually. Now, what happens is, there are issues associated with it. This task, first of all, has a dimension of caste biasness. Why? If you talk with a caste hierarchy, you'd be realizing that according to the government of, there are two reports. First of all, according to Government of India, the 97% or close to 97% involved in manual scavenging are from the scheduled caste community. What does that lead to is, that means certain particular caste hierarchy, who is at the lowest of the caste hierarchy, are the ones who are associated with this particular work. So this is associated with a stigma that only those lower caste people are doing this work. And that is why what happens, and another thing is that this work is not remunerative also. And that leads to discrimination based on, first of all, class also and caste also. And another thing is, that interesting is, the railways is basically the biggest employer. Over there, large number of manual scavenging activities take place. And this is quite shocking also. So we realize that because of the stigma that is associated with them, it creates a lot of problem. Next is, because manually it is being done, many times it see every year thousands of people die inside the sewers and the septic tank because they do not have protective gears. And they go inside manually. It leads to a lot of diseases, leads to a problem, discrimination, deaths. And that is what is a problematic scenario, and along with the stigma and the caste biasness that is associated with that. So first we have seen what is manual scavenging. India banned the practice under the Prohibition of Employment as Manual Scavengers and the Rehabilitation Act 2013. But even now, the practice continues freely. Even the railway ministry or the railways is the biggest employer of them. Now, the act bans the use of any individual for manually cleaning, carrying, disposing any otherwise handling matter, excreta, till it is disposed. So it basically goes against the manual scavenging, but we realize again it is going on. So in 2013, the definition of manual scavenging was also broadened to include people employed in clean septic tanks, ditches, or railway tracks. So that means those who are involved in cleaning in the clean septic tanks, in the ditches, or the railway tracks that excreta is there, cleaning, that also comes under the manual scavenging definition under the 2013 Act. But we realize even today that it is being done manually. The Act recognizes manual scavenging as dehumanizing. What does it mean? That means it is against the humanity because people tend to associate caste biasness with it and cites the need to correct the historical injustice and dignity suffered by the manual scavengers, because it is because of the caste hierarchy that certain people were forced to do these work in the course of thousands of years, and that led to a lot of injustice, discrimination against the scheduled caste community in particular. And that is why by removing these practices, we are basically trying to move towards giving them dignity, what they deserve. Let's move ahead. Reasons behind the prevalence of this practice. Please understand, there is lack of enforcement of the act. We right now studied that the railways as the biggest employer. So that means the government itself is employing the large number of manual scavenging. So there is weak implementation. Cheap labor. Example, the Mumbai civic body charges between 20,000 to 30,000 to clean septic tanks. The unskilled laborers, meanwhile, can be hired on a daily wage of 300 to 500 rupees. So cheap labor is there, and very easily it can be done rather than paying them large salaries to other groups or other companies who have an organized system of cleaning the septic tanks. Cheap labor can be there and that can be used. Lack of social mobility. Due to lack of basic amenities, education and employment, they do not have the jobs. So they tend to do this job which has been ancestrally done by their forefathers. Then again, that is basically one of the options that is left to them. In sanitary latrines, according to the Safai Karamchari Andolan, occupation persists mainly because of the continued persistence of insanitary latrines. That means there are 2.6 million insanitary latrines or dry toilets that require cleaning by hand. They do not have any proper flush system. They do not have a septic tanks where the latrine might be going. So they have this dry places where people basically have their excreta and they has to be cleaned by hand. If there are proper septic tanks and all where a cleaning discharge which are connected to the drainage system, proper excreta drainage system, that would have been better, but that is not present. Dry toilets basically lead to cleaning by hand, and that is what creates a problem where practice of manual scavenging still continues. Inadequacy of the government programs. The government programs are majorly emphasized on financial aspect and rehabilitation, not on removing the caste-based discrimination that has existed since centuries. Caste-based division of labor. Because we realize that it is one of the things is we cannot immediately shift to some other means, because there are certain people who we see as scheduled caste being associated with this particular task. Now, because it is being there, we realize that again caste and work is associated, and that is why we realize that manual scavengers are usually from the caste group, customarily regulated from the bottom of the caste hierarchy. So that is why people say that it is the role of this particular caste group to do it, and that is why we realize that the legacy of the people belonging to that particular caste group are continuing with this particular work. So this is again the issue that we see. Now, government intervention. Employment of manual scavengers, Construction and Dry Latrines Prohibition Act 1993 was again, employment of manual scavenger was declared as unlawful, but again it continued. Then we have the National Commission for Safai Karamcharis constituted under the National Commission for Safai Karamchari Act 1993 to monitor and recommend specific programs for the people belonging to the manual scavenging communities. National Action Plan for Total Eradication of the Manual Scavengers was launched in 2007. When we have self-employment schemes for the rehabilitation of manual scavengers initiated so that training can be given, loans can be given so that they move out from this particular set of work and find better employment opportunities. That is here, alternative occupations. Prohibition of Employment as Manual Scavengers and Rehabilitation Act 2013. Now, over here, please understand, we see this particular act, which we have seen the provisions over here also. This basically bans the uh, aspect of manual scavenging. Along with it, it expands the manual scavenging dimension which are present in along the ditches also, the railway tracks also, and along with it provides for the means of rehabilitation, alternative opportunity to work, loans, and also practice of the manual scavenging is taken as an offense also, which can be penalized also. So that is what is there. Then we have the Nirmal Bharat Abhiyan, which was replaced by the Swachh Bharat Abhiyan in 2014. We realized that over here also, when you're talking about Swachh Bharat Abhiyan, it by default incorporates that we need to phase out the dry latrines, have proper toilets. Moment we start having that, which we realize has increasing, we realize the practice of manual scavenging will decrease. But even today, we realize in the railway sections and in the even at the municipal corporation level, you realize a lot of manual scavenging still goes on, and that is what creates a lot of issue where poor implementation of law is very perceptible. Now, key features of the Act of 2013. See, prohibits construction or maintenance of insanitary toilets. That means that dry toilets are prohibited. Prohibits the engagement or employment of anyone as manual scavengers. Violation could result in imprisonment and fine of 50,000 or both. Prohibits a person from being employed in the hazardous cleaning of the sewers or septic waste, because you have to go without any gear or let us say any protective measure inside those sewers. Offenses under this act are cognizable and non-bailable. Cognizable, that means no arrest warrant is required. Non-bailable, that means you cannot get a bail on this. Calls for survey of manual scavengers at the urban and the rural areas in a time-bound manner, so that we really get to know that how many people are actually involved in this particular act. So this is again the way. So let's move ahead. What should be the way ahead? Technology adoption at a wide scale. Like for example, Hyderabad Metropolitan Water Supply and Sewerage Board is using mini jetty machines to clean those colonies and the sewerage places. So use of technology can be there rather than using the people as manual scavengers. Target-driven approach to means to success of the sanitary policy. Then we have awareness generation. We have enforcement of law, so that we realize that once the violation of law is basically being penalized, then automatically the practice of manual scavenging will itself decrease. Then a comprehensive rehabilitation package should be there, so that they can leave this traditional work and move ahead with some other alternative work. Investing in proper human waste management. So proper human waste management system can be there, where people of the scheduled caste community can also be a stakeholders, where commercialization of their work can take place. That is what is required. So this can be a way forward for the system. Let's move ahead. Topic 3, right to disconnect. See, what do you mean by right to disconnect? Please understand, right to disconnect empowers the employers to avoid answering calls, emails, or messages that are related to your work during the non-working hours. That means when you are in a non-working hours, you don't have to answer or are bound by the office to work during those times through calls or via emails or text messages. Now see, it recognizes the constant connectivity can lead to burnout, stress, decreased productivity, as employees anticipate work tasks even during the personal time. This has become very important because of late we realize few in the E&Y company also, one of the employees died because of these stress-related issues. Again, we saw a few other cases also because of the very strict working hours. Various corporate employees have facing health-related issues, stress, anxiety, depression, or even committing suicide for that matter. So we realize that that is why right to disconnect is very important, because when you are in a work hours, you work. When you are in a personal time, you need to leave your work aside, because that would otherwise lead to stress, burnout, anxiety, and a lot of mental and physical health issues. So by ensuring this right, employers gain freedom to reclaim their personal time, because that is required for your mental and physical well-being. Origin of the right to disconnect. The concept of disconnecting from work basically is rooted in Article 24 of the Universal Declaration of Human Rights. That basically means that Article 24 says everyone has a right to rest and leisure, including reasonable limitations of working hours and periodic holiday with pay. That means the Universal Declaration of Human Rights says one has to balance the work along with it the personal time. and you cannot be working all the time. Otherwise, what will happen? Both the lives will be impacted. So this is a part of the basic human rights under the right to disconnect, right? So let's move ahead. Benefits of right to disconnect. You realize that better mental health issues. We realize in India, 72% of the Indians are undergoing some or the other form of mental health issue because a lot of work-related issues are also rising. Improved work-life balance, because then you are able to give proper time to your work and also your personal life. Increased productivity, because if you're working all the time, you'll be realizing you're productive with respect to the work next day will decrease because you're all the time working. You do not get adequate time to sleep. You do not get adequate time for personal leisure. Next is physical well-being. Obviously, if you are completely occupied with your work, you will be having lesser time for, let us say, physical exercises, going to gym, going for a walk. Because if you are completely occupied with work, you are getting free at late in the night, you will be resting and sleeping, and next day again getting up and again working. Next comes enhanced creativity. Remember, creativity works only in the platform when your brain is at a calm state. When it is not calm, creative ideas and thought will never come. That is why when your work time and your office time and your personal time are balanced, then only you can be very productive. Now comes consequences of not being disconnected from work. Let us assume you are rigorously working and you do not follow this balancing of your personal time as well as the professional time. What will happen? Increased stress and anxiety, burnout risk. Burnout means a state will come where you will start hating the work that you are doing because it will break what we say as the elastic limit of work. Then you have disrupted sleep pattern, cognitive functions. It is very often because your brain is very hyperactive throughout the day for working. When you go to sleep also, then you will not be able to sleep properly. You'll be having sleep disorders. You'll be having cognitive abilities, able to not remember things, not able to, let us say, be in a proper interactive mood with others. Again, psychological disorders also come. Reduce job satisfaction. For the work that you are doing, will start hating it. Again, paradox of overwork. While overwork may seem like an increased productivity, it often leads to mistakes and inefficiencies. If you see that, okay, you're working a lot, that is good. No. What happens is with overwork, what work you are doing, its quality will decrease. That is what the problem is. Next, negative impact on creativity and screen time. You realize with the technology, you realize because most of the time we are associated with screen technologies, that will create issues, again, sleep disorders, that will create issues with eyes being impacted. It also will lead to sleep pattern distortion. So all these things do come along with it. That is why if you do not disconnect, you will be facing one or the other forms of issue that are present over here. Next, right to disconnect in India. India lacks specific laws with respect to right to disconnect. We do not have any specific law which mentions that. But however, the constitution and the directive principle of the state policies and the various judicial pronouncement have one or the other way mentioned about it. See, provision Article 21 of the Indian Constitution guarantees every citizen the right to life and liberty. So the life enshrined under Article 21 also has a right to leisure. Right to leisure and right to life, that means you can lead your life as you want, without any obviously disturbing someone else's peace, but you can read the life as you want. That leisure also comes with a right to disconnect where you have your personal time and personal space. That means under Article 38 of the Constitution mandates the state shall strive to promote welfare of the people. Under the welfare of the people, again, you should give them, or a balancing, or the law should be made where you balance the personal time and well as the office time. It is not that you can make a employee work continuously for 24 hours. Article 39E of the directive principle states that directs the policy towards securing the strength and health of its workers. So by default, proper and non-toxic working culture is important. Next, judicial precedents. Again, in the Vishakha in the state of Rajasthan, 1997, basically the Supreme Court very categorically said that dignity at the workplace is very, very important over here. Recognize the right to dignity at the workplace. Along with it, Ravindra Kumar Dhariwal versus Union of India basically stated, read Article 14 over here and stated that inclusive equality reasonably accommodate the persons with disabilities. What does it mean? That means the places where one is working should create an environment of viability, of inclusivity for every people, not that excluding subsection. So this also includes that a proper working culture in the places where one is working should be there. This is one of the acts. Praveen Pradhan versus the state of Uttarakhand, the High Court of Uttarakhand prohibited workplace humiliation. Excessive working, not listening to the employees is also humiliation. That is again leads to burnout. Now, in 2008, private member bill introduced in Lok Sabha delineated the right to disconnect, which was again not passed. So we realized that some types of provisions have been made and various laws have been attempted to be passed, but even now we realize there is no specific right to disconnect that is implicitly mentioned in the constitution, which is today's time is a need for the hour, where the companies should understand, for that matter, whether it is government, whether it is private, that people's personal life and the work balance should be there. Otherwise, that will lead to decrease in the productivity. Now see, challenges, lack of standard definition. We do not have any standard definition with what is right to disconnect. Different professions have different requirements. Now what happens, because some profession will require working for few hours, but a greater amount of revenue is generated, so you don't have to work for long hours. But some profession where income is less, it is based on hour, you will have to work for a lot of hours. So again, those issues depend from profession to profession, so you cannot create standard guidelines. Enforcement difficulties, because startups and all, very few people are there. You realize that they not be following exact intricacies of what the laws might be there. And what happens is that everybody wants a job, and in case when says that my right to life and leisure is there, they might be removed from the jobs. That is why they keep quiet. Again, enforcement difficulties. Impact on promotion and incentive. If you are very lethargic with respect to work, or say that we will not be doing extra work and all, you will be suffering during the times of the incentives or the appraisals that are given. So similarly, subjectivity with determining reasonableness. What does it mean? Deciding whether communication outside working hours is reasonable is subjective. Sometimes what happens is that you're talking to your friend who is your office colleague. They might be talking other things also, but you might be discussing certain issues with respect to office also. Now, how will you delineate whether the conversation is personal or office? That again creates issues. Time zone challenges. Now, what happens if a company is in India but working for United States? Time zones are there. Different time zones are there. That again creates issues. So one cannot go or compromise with that. Next is dispute resolution. Again, please understand, disputes may arise regarding the implementation of right to disconnect. That again creates problem, because you do not have any proper law in India right now. Technological dependence. With the increased digital world, technology allows seamless communication and collaboration. Disconnecting would create operational inefficiencies, because we are all connected via technology, and that might create a lot of issues. So these are the problems with respect to the aspects of right to disconnect. Recommendations for the economic survey. Extension of overtime working hours. Proposal to increase the working hours beyond the current limit, which restricts the overtime to 75 hours. Now this has been recommended by economic survey. Reduction in the overtime wages, suggesting reducing the overtime wages to make additional work hours more economically viable for employees. And increasing workers' monetizable time, relaxation of work hour restrictions. So we realize that economic survey has recommended certain things which are again towards increasing the work burden and decreasing the leisure time. So we realize that this, if implemented, will create a lot of problems also. We need to balance the work and the personal time. Over here, certain measures that have been made or recommended in the economic survey is again meeting the competitive environment is fine, but it will lead to a lot of problems in the future. Opposition plans to impeach the Uttar Pradesh judge. See, what is impeachment? Impeachment is a process of removing a judge of the Supreme Court or the High Court for the grounds of proved misbehavior or incapacity under Article 124(4) in case of a Supreme Court judge, and in case of Article 218 in case of the High Court judge. The concept and procedure of impeachment are laid down in the Constitution of India and the Judges Inquiry Act 1968. Now this is laid down. Now let's see, what does it say? It says, see, procedure for impeachment, ground for removal. Along the constitutional provisions, the Judges Inquiry Act 1968 defines the ground on which a judge can face imprisonment, such as misuse of office, grave offense undermining the judge's integrity, or any contravention related to any constitutional provision. Then next would be initiation. The process begins with a signed motion by 100 members of the Lok Sabha or 50 members from the Rajya Sabha, which is submitted to the speaker or a chairperson respectively, provided under the Judges Inquiry Act 1968. Now what will happen? A constitution of inquiry committee, Now, a committee is created in order to inquire of the possibilities of the charges that have been made against the judge. Upon admittance of the motion, an inquiry committee is formed consisting of a Supreme Court judge, a High Court Chief Justice, and an eminent jurist. The committee will frame the charges on which the investigation will be conducted. A copy of the charges will be forwarded to the judge in written, so that these are the charges that have been framed against you, and this is what the committee is basically decided, that this is right, and these are the charges against you. So next, what happens? Inquiry and report. The committee carries out an in-depth inquiry and the allegations. Post the investigation, the report is presented to the speaker or the chairperson, outlining their findings. Now, parliamentary process. If the committee deems that the judge is guilty, both the houses of the parliament can then discuss the motion. The motion, to pass, it needs special majority. Special majority means majority of the total members of the house and a majority of at least 2/3 of the members present and voting. Presidential order. On this being passed, we realize that a successfully passed, then obviously the president can sign that, and under Article 124(4), the judge can be removed in case of the judge of the Supreme Court, and in case of Article 218, the case of judge of a High Court. So this is basically the process. Notable instances, we realize Justice V. Ramaswamy, 1991, was the first judge against whom impeachment motion was passed. Till now, no judge has been impeached. There have been motions that have been passed, but no judge have been impeached. Second was Justice Soumitra Sen. Basically, he resigned even before the motion could have taken place. Then against Chief Justice Deepak Mishra also, again, motion was rejected by the Rajya Sabha, so proceedings could not move ahead. So these are three of the instances which we can see against which motions had to be taken but were not taken up. Now comes the prelims topics. Vaikom Satyagraha, this is mentioned as topic 5 in the process. Please understand the background. Temple entry movement. This basically is related to the temple entry aspect, where discrimination on the basis of caste were prevalent in the various temples, and the people from the lower caste were not allowed to enter the temples. So this is what was the scenario with respect to before the Vaikom Satyagraha. So lower caste Hindus were not allowed to enter the temples because of the caste biases. Discrimination. In the Kakinada meet of the Congress Party in 1923, 𝐑𝐄𝐂𝐻𝐿 presented a report citing the discrimination that the depressed classes, or what we know as the scheduled classes today, face with respect to the temple entry. And that is why what happened is, there was again a consensus that certain action should be taken with respect to the discrimination that is being faced. The formation of a committee. In Kerala, a committee was formed comprising of the people from different castes to fight the untouchability. Under this committee was chaired by K. Kayyalappam. Again, other members were T.K. Madhavan, Velayud Menon, K. Neelakantan Namboodirthy, and K.R. Krishnaswamy Iyer. Now, these were the ones who were basically the members that were there. And these were leading the movement also in the Vaikom Satyagraha. Now, what happens? Launch of the temple entry movement in February 24, launched as the Kerala Paravartanam. Now this, in order to get the temple entry and the right to use public roads for everybody. Now this is what happened as a background with respect to the Vaikom Satyagraha. Now see, what is Vaikom Satyagraha? Overview. Vaikom Satyagraha was again 1924-25 was a Satyagraha in Travancore, India, where we realized that it was against the untouchability in the Hindu society. Where we realized center of the Vaikom Satyagraha was, it was centered at the Shiva temple at Vaikom near the present day Kottayam. Aim of the movement was the Vaikom Satyagraha aimed at securing freedom to all sections of the society through public roads leading to Shri Mahadeva temple in Vaikom. In order to gain access to that, this Satyagraha was launched again against the caste discrimination. Mahatma Gandhi's association, non-participation. While he was consulted at every stage of the Satyagraha, Gandhiji neither led or participated in it. But we realize, Gandhiji later on we realize that visited it. Gandhiji visited Vaikom only once in the 20-month-long struggle, and Gandhiji's 10-day visit was, however, the turning point in this particular movement. How? 3 proposals of Gandhiji were given. First proposal, the first was that holding a referendum among all adults, either in Travancore or Vaikom, with respect to the rights. Second proposal was mediation. If this proposal was accepted, Gandhiji would nominate Madan Mohan Malviya to represent the Satyagrahis. Third proposal, the orthodox should produce a scripture text that authored practice. That means the the people who are restricting the access of the usage of road and the temple entries, they should give a proof in which scripture it is present that this practice of untouchability should be practiced. So again, what happened? Gandhiji left if the Orthodox chose. So he basically challenged the Orthodox people with respect to this practice. Aftermath, acceptance of the third proposal. The Orthodox accepted the third proposal and produced a text called Sankara Samriti in their defense. That over here, the aspect of untouchability is mentioned. Authenticity of the text. Gandhiji doubted the authenticity of the text but promised to get back after consulting the experts. Over here, Vattanlal Narayan Menon confirmed that it was not reliable. So that means that text on the basis of which untouchability was being practiced, they said that was not itself a reliable text. And a lot of interpretations have been made to that. So meeting with Maharani regiment, Gandhiji next met the Maharani regiment as she expressed her opposition in favor of opening all public roads. So all public roads were basically opened post that, because the text on the basis of which the discrimination was being promoted was itself not authenticate. Next, move ahead. Okay, we have the Voronezh radar system. What is it? Voronezh radar system is critical component of the Russia's early warning and missile defense infrastructure. It is capable of identifying and tracking threats of any missiles that are coming, including the ballistic missiles and the aircraft, for a distance up to 8,000 kilometers. So this radar can trace any missile or any aircraft that is coming from a distance of 8,000 kilometers also. So this is a very comprehensive, a very modernistic radar system of Russia. Now, introduced in 2009, these radars have been operationalized since 2012 and are strategically deployed across Russia to basically comprehensively cover the airspaces with respect to any attack that would be done on against Russia. These radars employ phased array technology in which rapid electronic steering of beams is done. So it basically uses a rapid array technology where beams are basically seen and which are basically note down or observe any or track any particular object that is coming towards Russia. Now, there are several varieties are there. You don't have to remember this variety. The meter, Vorozin M, decimeter, then you have the centimeter, Vorozin cm, the wavelengths are there. You don't have to remember that, just to know that there are variations that are existing. Different Vorozin radars can work in unison and are integrated missile attack early warning system. So it is not one radar. Those radars are placed at various places across Russia, and they are integrated to each other. That basically leads to what? A comprehensive missile system that is created over here. That is what becomes important over here. Okay, let's move ahead. India Skill Report 2025. This is important. Please understand, India Skill Report is published by Wheelbox in collaboration with All India Council for Technical Education and CII and Association of the Indian Universities. Now, what are the purpose of it? Assess the employability status, whether they are employable, whether the Indians are employable or not. Track the skill trends, what are the skill levels of the people. Promote global mobility, because it highlights that when we talk about global mobility, we need to understand that people would be moving to various countries, whether they are able to match the skill level of the other countries, or will they be employable in those countries. That is what is being assessed over here. Now, what are the overall trends? National employability. The employability rate has reached 54.81, a notable increase from the 2024. That means the people who are capable of being employed has increased. Decade of growth. Overall, the last decade employability has risen from 33 to over 50%. Again, a good news. Youth focus among 22 to 25-year group. The employability are high, particularly in the Kerala, which boosts to be 87.47. So that means in Kerala, in the youth from 22 to 25, 87.47 can be employed because of the skills that they have. Gender variation. Gender analysis show employability rate for men is expected to rise to 53.5% and from 51.5% in 2024. But we realize that women employability rate is projected to decline to 47.5 from 50. So we realize this, the employability ability, that means the ability of a person to be employed with respect to men has increased, but with respect to women has decreased. This is a stark problem that we see over here. Varying employability. Again, management graduates again have the highest employability with respect to course you have done, that we see. Top states: Maharashtra, Delhi, Karnataka, Andhra and Kerala. Again, emerging technologies, we realize that artificial intelligence sector, those sectors where employability is increasing. Cloud computing, again, a place where a lot of employability or expected employability is going to rise. Then we have the sustainability and green energy sector, where we realize that a lot of scope with respect to employability is there. Then healthcare and the aging population, because we realize that the aging population is going to increase with time. That is why new branches of geriatrics and gerontology will increase. That is why these sectors become very, very important. Then digital skills for the global economy. IT professionals and hybrid modes are one. We will be realizing that a lot of people, more IT engineers will be required, especially in the cases of cybersecurity, cloud computing, artificial intelligence. Over here, that trend will rise in the coming time, because we see that the digital space is rising, and along with the requirements will also rise. So India's opportunity, global trend mobility. So we realize that Indians are going to move to the other parts of the countries, or for that matter for employment. So that is going to be there. Along with it, impact on the global economy. Hybrid models are going to be there, which is going to contribute close to 500 billions to the global economy. This is what is basically being represented. You need to have a brief idea with respect to what the Indian trend was. More than that, this global trend is something, if you do not focus on also, then it is fine. But majorly the Indian trend that we have studied. Now comes the MCQs. First question. Options, answer. Question 2, please pause the video while you are seeing the video. Options, answer. Question 3 with the options, answer. Question 4, options, answer. Question 5, options, answer. So this was the analysis of the Hindu from my side. Hope you enjoyed it, liked it, and we'll be continuing this session again. Take care and Jai Hind.